Hello everyone, it's Chris Clark with DiscGolf.Law. During the disc golf off-season, discussions inevitably turn to player contracts. Who's leaving? Who's staying? What will the unique dynamics, financial and otherwise, mean for contracts in our industry? Contract drafting and negotiation are a big part of what we do here on a daily basis. We've prepared a list of key points that both sponsors and players should be thinking about when entering into a contract. So first, let's make sure the party names are correct, especially as we have seen some consolidation within companies in the disc golf industry. If you're a player and you're entering into a contract with a sponsor, pay careful attention to exactly who it is you're entering into the contract with. Often, you will see the name of the company, and then there will be a term that says something like, and its affiliates. This could really make a big difference in a player sponsorship contract because often the player is intending to align himself or herself with a particular brand. Well, if your contract is with a company that has a number of affiliated brands, you may not necessarily be entering into the type of deal that you expected. Number two, let's make sure that the term of the contract is clearly spelled out in the document. Now, from the player side of things, if you are an up-and-coming player with a lot of potential, it's likely you should be looking for a shorter term contract. The reason for this is you want 1 year, maybe 2, to prove yourself and prove how great you are and what you can do so that the next contract you negotiate, you'll have a lot more bargaining power. On the other hand, if you're a player who has reached your potential, or maybe even in the later years of your career, you would likely be looking to lock down a longer term contract. It's unlikely that a year or two you're going to have a superior bargaining position than what you have now. And so locking down the security of that longer term is likely to be the best move. Obviously, if you are a sponsor, you want the other side of the coin. You would love to lock down an up-and-coming player with a lot of potential into a longer-term contract so that you can reap the benefits of the investment that you're making early on. Players and sponsors, please be sure that the language around player apparel and event requirements is clear. For a player, you just want to know, what are the requirements? What are my sponsor's expectations of me when it comes to the apparel I must wear and when? Every time you play a round of disc golf? Every time you play a competitive round? Every time you play a sanctioned round? Or maybe is it just for Elite Series and majors? You want to make sure that that's clear. And also, what events does your sponsor intend for you to participate in? And when I say events, I don't just mean competitive disc golf tournaments. Often sponsors will hold events either adjacent to a tournament or even at times unrelated to a tournament. Just make sure you're aware of those. And if it creates a conflict for you or for your schedule, you'll want to negotiate that in advance. Now, from the sponsorship side, obviously it's great to have your sponsored players wearing your apparel and attending as many events as possible. So you'll want to try to explain to the player the benefit of that and why that's a requirement in the contract. All right, next issue, who owns the intellectual property? I'm talking primarily about the intellectual property used to identify the player. It's pretty much a settled issue that a sponsor is going to own the intellectual property that belongs to that sponsor, trademarks that might protect their brand identity, or patents protecting their products. But it's a little bit of a gray area for players. Oftentimes a sponsor will invest quite a bit into developing something like a logo or a website for a player. Let's be real clear in that contract who owns the rights to that website or to that logo. And obviously players, we want to see you advocating on your behalf to own those things. For a manufacturer, if they can work out a way where because they're investing the money, they own those assets, that's something that can be negotiated as well. Next, let's talk about the scope of the sponsorship. Are you intended to represent all of the various products and services of your sponsor, or is it narrower than that? This comes up most frequently when we see disc manufacturer sponsors that also make other things, like bags, for example. Players, you just want to make sure that your contract allows you to go out and seek these more niche type sponsors in addition to the money and the contract that you've got with your primary disc sponsor. Disc sponsors, on the other hand, as much as you can lock down your player to identify with your brand, the better, especially if you want some control over the types of products your sponsored player is able to align themselves with. So if that's a concern for you as a sponsor, make sure to include it in the contract. Okay, now for the big one, compensation. I'm going to run down the various types of compensation that we typically see in sponsor contracts and just give each one of these some thought, whether you're a sponsor or whether you're a player, about how to negotiate this in a way that is advantageous to you, but also fair and something the other party is willing to agree to. First of all, signing bonus. Doesn't really require a lot of explanation. Players, try to get as high of a signing bonus as you can. Sponsors, I tend to, when I represent sponsors, advocate for more performance-based compensation, so I would recommend for sponsors not to have a signing bonus. Next is the monthly stipend. This is not a performance-based metric, at least not directly, and so from a sponsor's point of view, I would be pushing for a low monthly stipend. Players, it's unpredictable out there. You don't know what's going to happen. You're going to be negotiating on behalf of a high monthly guaranteed stipend. The next one is royalties. And when I say royalties, this typically means a percentage of disc sales or other merchandise sales. This would be something where, as a player, I would be trying to drive more of the dollars toward the monthly stipend. If I have to negotiate away some of the upside on the royalty side, but get it on the monthly stipend side, I probably would do that for most players. This doesn't apply to every single player, and those of you that it doesn't apply to, you know who you are. But there's just too many variables. You know, might there be manufacturing issues that prevent your discs from being made? Do you understand the method the sponsor is using to calculate royalties and payments based on physical goods? Those are the things I would be thinking about and that I would be talking about if I were representing a player. Flip side is obviously the sponsor. As a sponsor, I am going to advise moving dollars away from things like signing bonus and monthly stipend, and let's make the royalty offer a little more generous. Rising waters lift all ships, or whatever that saying is. We want dollars coming in the door so that the overall health of the business is sustained. Next form of compensation is performance bonuses. From the player's side, I'd rather that money come in the form of a monthly stipend than in performance bonuses. It is grueling out there on tour. The talent is getting better and better. It is very difficult to predict how many times you are going to podium, much less win. Flip side for a manufacturer, when one of your sponsored players makes it on the podium of a tournament, or even better yet, wins, that is exposure for your company and your brand. I would highly incentivize my players to win tournaments, make coverage, anything that's just going to give me and my brand more visibility. Players, what expenses will your sponsor cover? Frequently, this could be tournament entry fees, but there's a laundry list of others that should be considered, and I don't need to go into all of them here. This is something that if you have the ability, if you have the negotiating strength, and it might mean you need to give on some other issue, but I would really be asking for the sponsor to cover a range of expenses that are directly associated with being a touring professional disc golfer. On the sponsorship side, I would recommend not engaging in a negotiation around expenses. I think it's fine to pay tournament entry fees, but it seems like a bit of a slippery slope where once you start paying a few things, now you're paying more and more. It almost becomes like another monthly stipend on top of the one that you're already paying. Now, let's talk about what happens if somebody breaches the contract. There are a few ways that this could be handled. From the player's side, if the player breaches the contract. What you would want is what we call a notice and cure period. Your sponsor would be obligated to notify you, hey, we think you've breached this contract, and here are the ways in which we think you breached the contract, and you have a period of time, typically 30 days, to correct these breaches or address them or bring yourself back into compliance with the contract, and then we'll just go on as if it had never happened. Sponsors, on the other hand, would likely like to at least have an option to terminate the contract based on a player's breach. Now, what if the sponsor breaches? Well, players entering into this type of a contract, the most likely way that a sponsor would breach the contract would be to not pay you. The remedy that I see for players, if a player is required to engage the services of an attorney in order to enforce the player's rights under the contract, the sponsor pays the player's attorney's fees. Because if players are required to go out and hire an attorney to enforce their right to receive their monthly stipend or their royalty check or whatever the case may be, they may likely spend as much or more in attorney's fees than they would receive from the check. So that doesn't really make a lot of sense unless you add the kicker on there, and oh, by the way, the sponsor pays the attorney's fees. From the sponsorship side, I would not recommend agreeing to that. What I would recommend agreeing to is similar to what we talked about on the player's side for a player breach. Give us a notice and cure period. This frequently comes up when a check forgets to go out. Just that single event alone, I think, shouldn't be grounds to terminate the contract or have a lawsuit or anything like that, especially if the sponsor is willing to use this notice and cure period to pay the player what they owe. How about what happens if the player gets injured? This one is pretty straightforward. I think on the player's side, we would expect the sponsor to continue paying the monthly stipend to the player at least for the remainder of the season. Sponsor side maybe want to offer the option to pay a lump sum to terminate the contract early, or maybe the contract goes on and the payments stop because there's some minimum amount of events that the player is required to play in and they're not playing in it. This is a tricky one. It's touchy. It brings in issues with healthcare and insurance and all this kind of stuff. But as a player, negotiate hard that in the event of an injury that doesn't allow you to play, you continue to receive some form of compensation from your sponsor. Sponsors, I recommend building that in and also building in an exit route for you that's fair. And the last thing is, how are disputes in this contract handled? I think from a player's point of view, you would probably want to advocate for some form of alternate dispute resolution, mediation followed by arbitration. That's just a method of resolving disputes that doesn't involve filing a lawsuit and taking somebody to court. One other thing I would say about that is the alternative dispute resolution clause in your contract should be drafted in such a way that it's realistic for you, that it allows some flexibility. If one weekend you're in Charlotte and the next weekend you're in Minnesota and the next weekend you're in Texas and the next weekend you're in California, you get the idea. We don't want to make it inconvenient for you to have to go to some physical location, at least not during the season. A virtual mediation, something that could take place over Zoom or some type of video conference technology, that would be one option for mediation. And then if you do have to have an arbitration, which typically does require people to be in the same place, let's do that in the off season and let's choose a place that's convenient for you. Flip side, for the sponsors. Sponsors typically dispute resolution would be a lawsuit in court. This isn't a hard and fast rule, but we often see situations where alternative dispute resolution favors a party with fewer assets or fewer resources. Whereas taking somebody to court, having a lawsuit, would tend to favor the party that has greater assets or greater resources. And that's partly just because of the simple reason that litigation is extremely expensive. If I am a sponsor and I'm advising them and my ethical obligation is to look out for their best interest, I would be telling a sponsor, we don't want an alternate dispute resolution clause in our contract. We want a choice of law to be in the state where we, the sponsor, are located. And we want the venue for the settlement of disputes to be the courts in whatever city and state we are located in. Hopefully you found some of that information useful. If you're a player or a sponsor and are facing an upcoming contract negotiation, or you just want to have your contract reviewed by a professional, please feel free to reach out. If you would, please like this video, leave us a comment below, and subscribe to our channel. And as always, thanks for watching.